Good afternoon, guys. How you guys doing? It's your girl, Legal Bees. And so this comment and about ineffective assistance of counsel, you were discussing the defense attorney. And so, long story short, when it comes to appeals in Michigan, if you have gone to trial, you have an automatic right to an appeal to address all issues and defects that you may argue occur during your trial and pretrial stage. Those issues have to be preserved for trial, i.e., objections, motions, things like that, for it to be brought up on appeal. So this case took place in the circuit court. You have 42 days from the time of your sentence to either appeal or file a motion for a new trial. Once you do one of the two, the transcript is requested, which the judge actually mentioned about the cost of the transcript. So I'm thinking that it may have already been requested. The transcript is requested, and then briefs are filed, and then it goes from there. So it doesn't have to go through any particular habeas stage. It doesn't have to go a certain route. Now, if you raise the issue of ineffective assistance of counsel for trial, if you file a motion for a new trial within that time frame, you can also raise what's called a Ginther hearing. A Ginther hearing is where you basically say to the judge, look, my trial, I didn't get a fair trial. I wasn't given fair due process because of my attorney. My attorney was ineffective, and this is how she was ineffective. And then you would list off in your motion all the reasons you believe that your attorney was ineffective. Once that happens, the judge will either decide to say, hey, okay, I'm in agreement with some of these things. Let's have an evidentiary hearing. And then the attorney actually has to come in and testify. And then the judge would determine whether or not there's a true finding of ineffective assistance of counsel at a Ginther hearing, and then set that matter for a new trial. That can be done whether you go appeal or not. And tactically, what can happen sometimes is you file the motion for new trial. You raise it, try to get a Ginther hearing. If it gets denied, then you can also add that to your ineffective assistance of counsel argument at appeal, saying, hey, there wasn't a true finding of fact. She testified to these things. The circuit court got it wrong, or the trial court got it wrong, and this is how she was ineffective, and I'm entitled to a new trial. So that is the ways that ineffective assistance of counsel can be raised. Now, do I think that argument is going to be raised on appeal? I think it depends on who the appellate attorney is. If Ms. Smith does the appeal herself, obviously you can guarantee that that will not be raised. If another attorney handles the appeal or ineffective assistance, you could be guaranteed that it will be raised. That is like the kicker here. So, now that they've been sentenced and as this moves forward, it'll be interesting to see what happens at the appellate level. Will Shannon Smith remain counsel for Jennifer Crumbley, or will she get new counsel? I think the smarter end would be to get new counsel. Just because I think in this case, it is easier for, and I'm not saying Shannon would do this, I'm saying it's easier for an attorney to, quote unquote, cover their tracks if they're also representing you on appeal, depending upon the basis for that appeal. Now, we all saw all the comments that were on YouTube, TikTok, Facebook, under the news articles, the videos. Everybody, their mama, daddy, and grandma had an opinion about the representation of Jennifer Crumbley and Shannon Smith. Not so much when it came to James Crumbley. Like, I can honestly see his attorney still representing him on appeal, because Their trial was essentially plain and mundane, just like any normal trial kind of is. The only thing that spiced that trial up was the issue with the threats made by Mr. Crumbley. So outside of that, I can wholly see if Mr. Crumbley kept his attorney for appeal. I can see that. Miss Crumbley, I wouldn't recommend it. I wouldn't recommend it for Shannon or for Miss Crumbley. I just wouldn't. Yeah, I wouldn't. So, hopefully that explains our appellate process a little bit, how ineffective assistance of counsel can be raised. And, just give a little insight as to how things work here in Michigan. And generally speaking, they kind of work that way around the country. It's just there are different particular time frames and different steps that have to be taken sometimes in different parts of the country, different states, etc. Because we all have our own court rules. We all have our own ethical rules. We all have our own particularities and statutes and whatnot. So generally speaking, that's how that goes. Let me know if you have another question about appeal, ineffective assistance of counsel, or motions for new trial. I'm about to limp, as my assistant, my friend, and my husband would say, I'm about to limpy get my ass into this courthouse. I'm about to limp, and you see all those stairs? You see those fucking stairs? I don't even know where the goddamn handicap ramp is. I have no clue. And I'm certified handicap. Certified. Okay? So, I'm trying my fucking patience. It's about to be some interesting shit.